appeal, but heard the matter of Vodafone Ltd and Gencomp Ltd in another.
Good morning, my lords.
Morning, Mr. Reid.
Before I go back to where I ended yesterday afternoon, there's one thing that those behind me have wanted me to make absolutely clear, if I didn't make it clear yesterday, and that is the question of how binding agreements and confer agreements would operate alongside each other. And the core point we say is that where you have a situation, as indeed here, where you have two parties, one conferring, one wanting to be bound, then one would normally do that through a tripartite agreement. And that's precisely what was sought in this particular case. And indeed, there's no dispute that the tribunal, certainly before your lordships, that the tribunal has power to actually be able to order it, because that was the fourth preliminary issue in the case, and it was accepted that there was jurisdiction to do that. There were some observations about whether or not bilateral agreements or tripartite agreements were better, but of course that was being left for a later stage to see whether or not the parties agreed anything, how they agreed it, and whether there was any further material. But in our respectful submission, it doesn't really matter, even if you do have separate agreements, because both Gencomp and APW will have entered into their respective agreements, and that will make them parties to a code agreement for the purposes of paragraph 31 and paragraph 33. So at that point, the issue, the complaint that APW has, that as a concurrent lessee, it doesn't actually have the opportunity to terminate the agreement under paragraph 31, falls away.
So can I just get this, see if I understood this? You say APW is not currently entitled to terminate under paragraph 31.
Yes, my lord.
You are therefore entitled to apply under paragraph 20.
Yes.
And you can make your application against both APW and Gencomp.
No, only against APW under part 4. We say that under part 5, we have to make the application against Gencomp under part 5.
So you make your, let's assume that that's right. You make your application against APW under part 4. You make a simultaneous application against Gencomp after under part 5. The tribunal orders all three of you to enter into a single tripartite agreement. At that point, APW does become party to a code agreement, and therefore it could subsequently terminate under paragraph 31. So if, for argument's sake, APW has an overriding lease for, let us say, 125 years, and it says, well, we intend to put a new flat on the top of this block in 5 years' time, that would be reflected in the tripartite agreement that the tribunal would order, so that when the 5 years had elapsed, APW could then terminate and carry out its development.
Yes,
that's how you see it working.
Yes, and indeed, break clauses are regularly inserted into code agreements.
So this impasse, so to speak, is a one-off and is cured as soon as your application has been determined by the tribunal.
Exactly, my lord. And I'll come back to why we say that it's not the asymmetrical problems don't really, in reality, exist. And I'll come back to that shortly. But first, I want to take one back to Compton Beecham and just briefly recap where we say we got on that. I don't know whether my Lord Justice Nugee wanted an additional question arising out of that.
It was just when my Lord was explaining what your position was, which I think I've understood. I've not understood why you say when you apply under Part 4 against APW as the occupier, you can't also apply against Gencomp under Part 4 as somebody who you want to be bound.
Well, it would be nice if we could apply under Part 4, but the core problem we see is that one has the problem that Compton Beecham throws up, which is that parties to, where a party has available to it a remedy under Part 5, that is the remedy that should actually be used.
You don't have a remedy under Part 5. I thought the whole point was You don't have a remedy under Part 5, that's why you're going under Part 4.
Well, we don't have a remedy against APW, but we do have a remedy against Gencomp.
What is the remedy against
Well,
Gencomp?
we-
Because you can't ask under Part 5 for Gencomp to grant you a new lease.
A new conferral agreement. No, I agree. We entirely agree with that. But this goes to the point that my learned friend was adducing yesterday of somehow the agreement flipping under Part 5. The answer is it's perfectly permissible under Part 5 where there is an existing code agreement, whether that code agreement is a conferral or binding, for us to apply to the court and say we want it changed so that it ceases to be effectively a conferral agreement, but it's an agreement that still binds you to the code rights that will be granted in respect of the premises, albeit that has to be dealt with under Part 4. Now, the problem with this, my lord, if I can put it like this, is that it's trying to deal with the situation that's being generated by the observations in Compton Beecham about that where Part 5 is available against a party, that is the route one must use. And we say that route is available because we can apply under paragraph 33(1)(d) and obtain an order against Gencomp. But it doesn't necessarily mean that it has to be an agreement in the same form, i.e. conferring rights. Perhaps, my lord, as the point's been raised, I can take you straight to it. It's page 438 on in the authorities bundle at tab 21, second authorities bundle. And my lord, at paragraph 33(1), one sees that an operator or site provider is a party to code agreement by which a code right is conferred by or otherwise binds the site provider. So there's the gateway that the site provider has to have conferred or otherwise been bound by a code agreement and be a party to it. Now we say that Gencomp satisfies both those conditions for those purposes. And then at 33(d), one sees that the existing code agreement should be terminated and a new agreement should have effect between the parties which confers a code right on the operator or provides for a code right to bind the site provider. So it is possible, we say, for us to serve a notice on Gencomp under paragraph 33(1), because it satisfies the gateway conditions at the start of the paragraph, but then we can seek under paragraph 33(d) an agreement that provides for a code right to bind to the site provider. And then when one comes to paragraph 34(6), which is dealing with new code agreements, where there's an order for termination and a new agreement, the court may order the termination of the code agreement relating to the existing code right and order the operator and site provider to enter into a new agreement which either confers a code right on the operator or provides for a code right to bind the site provider. So there is nothing in section 33, paragraph 33 and paragraph 34 that precludes us going under Part 5 against Gencomp. Now, if that, in order to obtain a binding agreement. Now, if that is right, then on the dicta in Compton Beecham, that is the route we must use.
So let me just be sure I've understood what you say you are doing. You apply under Part 4 against APW for the conferring of a new code right. Then you apply under Part 5 under 33(1)(d) and in default under 34(6) for that new code right, the one that APW has just conferred, to be binding on.
Yes.
And you say you can do all that in one combined application, resulting in one tripartite
Yes, we can.
agreement.
It's using two different, obviously, jurisdictional routes, but it does not prevent us actually being able to deal with them at the same time. The tribunal, one of the real advantages of the new code is, of course, they're all being dealt with through the Upper Tribunal, which is a tribunal that's experienced and knows all about these cases. And they use their case management powers to ensure that the right parties are before the court at the right time. And that's why I started all of this discussion by saying, well, actually, what would normally happen in this situation is there'd be a tripartite agreement. So the tripartite agreement would be put to both APW and Gencomp, as indeed it has in this case, and they would be invited to agree or negotiate on those terms.
Well, why would Parliament have chosen such a Byzantine procedural structure?
Well, my lord, the problem arises because of the dicta in Compton Beecham.
You say dicta, is that ratio? Are we bound by it?
Well, I think it's very difficult to my learned friend is urging you to accept it is the dicta of Compton Beecham, and we say, well, if it's there, it's likely to, if not be binding dicta, at least be very strong overture that is the route one must go down. And if that is the logical consequence, then the code still provides for it, still covers it. As with a lot of the code, it's because it actually has a sort of unified approach, structure that actually approaches these things in a logical way. It does mean that logically you can achieve the result that one could have a Part 5 agreement against Gencomp and a Part 4 agreement against APW.
On the face of the code, leave aside what's said in Compton Beecham, there's no reason why you can't have a Part 4 agreement against both APW and Gencomp.
Exactly, my lord. I think that is clear from the language of the code. It is only the intervention of Compton Beecham and the discussion about how once Part 5 is available, it must be used, that creates this problem. But the core point is it's only available against one of the parties. It's only available against Gencomp, we submit, because against APW, that is not a part of the code agreement, and so therefore we have to look for an entirely new agreement to make it a party to the agreement. My lord, as with a lot of the code, it's very easy to say, well, perhaps the solution is this and the solution is that. But as I've already indicated, the real difficulty with these outlier situations, if I can call it that, which were never discussed in the Law Commission's statement, nor indeed by Parliament. The real problem is that what one cannot do is use them as a method for distorting what otherwise seems to be the clear structure of the code. Now, if the Supreme Court has in its dicta made clear that where Part 5 is available against a party, then that is obviously the route that can be used, and if one follows that, then that is the methodology by which one can actually resolve the matter by taking the matter to the tribunal. And the tribunal will be very astute to ensure that where you have this type of tripartite situation, all the relevant parties will be before the tribunal at the same time. I mean, it's a illustration of the way the tribunal has bent over backwards to ensure that there is a unified overall approach to the interpretation of the code. You have the situation where, in fact, there have been landlord and tenant renewals under Part 2, which have been specifically assessed, not in the tribunal, because obviously they have to go to the county court, but with the deputy president of the tribunal.
Oh, you're talking about Part 2 of the 54 Act?
54 Act, sorry, my lord. But the deputy president has sat in the county court to deal with them. Although it may look slightly odd that one's ending up with two different jurisdictions to achieve a tripartite agreement, the tribunal is very astute to make sure that there is clear symmetry between the various parts of the code.
Well, I think they're about to change the jurisdiction. They've passed some legislation saying that regulations can be made to transfer the county court jurisdiction to the Upper Tribunal in 54 Act cases about telecoms.
Yes, I think that's right. But of course, obviously, the whole gist of the situation is to try and ensure that everything goes to the Upper Tribunal. The Upper Tribunal then decides where exactly the cases should be allotted to. And in a case like this, there is no doubt at all, as indeed reflected by the preliminary issues decision in this case, that the Upper Tribunal will be keen to ensure that there is some form of workable solution within the code. I hope that deals with your lordship's point.
Well, I'm now left confused as to what the practical difference is between your application against Gencomp being under Part 4 and being under Part 5. There's a difference in the notice period. One is 28 days and one is 6 months.
Yes.
Are there other practical differences?
other than
Are the grounds of opposition different?
and no, because obviously the
One of the grounds of opposition is it doesn't meet paragraph 21, is that right?
yes. So in other words, there is a clear symmetry between the rights to for the tribunal to refute, or the tests that the tribunal has to go through under paragraph 21. So if one looks at paragraph 21 at page 424, the court can only make the order if it deals with the question of prejudice. And redevelopment, as one sees from 21.5, is one of the core points that is actually dealt with in paragraph 21. And then when one goes on to paragraph 31.4.
So just hold on a minute. 21.5, on your interpretation, is talking about APWs, or the overriding lessee's intention to develop, because they are the relevant person, aren't they?
Yes, because they're the party we will seek to confer the code
Yes.
rights. So if they want to say, no, we want to redevelop, then that is the objection that they raise and put before the court, and the court will refuse it if it agrees that it's one of the reasons, my lord, why break clauses are almost, where there's a question of redevelopment, are almost certainly included within the agreement, because otherwise one wouldn't get the code agreement under paragraph 21.5. And then when one goes on to paragraph 31, one sees in paragraph 31.4 on page 437 in the authorities bundle that various grounds are set out, and we've seen at 4D the mirroring of paragraph 21, and we see at 4C, one might have thought that it was possibly already included within paragraph 21, because of course we've seen the redevelopment point in paragraph 21.5. But it's expressly included as a further reason for not renewing the code agreement under paragraph 31.4c.
But this time, that refers to Gencomp's intention to develop, not APW's.
Yes, in the concurrent lease example, that is absolutely right. That it is Gencomp that primarily has the right to use paragraph 31, because we say APW is not a party to the code agreement, and therefore it doesn't qualify under paragraph 31. And the other 2 points obviously are dealing with, if we like, the track record over breaches and or deed payments. I want to come back to those in due course, but what I'm trying to illustrate by that is there isn't actually a huge difference between paragraph 21 and paragraph 31. So it doesn't, in essence, matter which route one goes under. But I'll come back to those provisions in 31.4 shortly. Can I just return to Compton Beecham? And I don't really want to take you back to it, because obviously your lordship's looked at it with some length.
Sorry, can I just understand the interaction between 21 and 31? Let us suppose that there is a concurrent lease and a freeholder, and there is a code agreement which an operator holds, and the operator has the most appalling record of non-payment of rent and breach of obligation and so forth. It applies under part 4, paragraph 20, against APW, concurrent lessee. The appalling track record is not a reason, is it?
Well, we say it can be a reason because it will be taken into the prejudice that the party may suffer.
Capable of being compensated by money.
Well, there is a limit to how much one, if one goes on to, if one perhaps goes back to paragraph 21, at page
424.
I'm grateful, my lord. You can see the first condition is the prejudice caused to the relevant person by the order is capable of being adequately compensated by money. So that's paragraph 21.2. But the second condition is that the public benefit likely to result from the making of the order outweighs the prejudice to the relevant person. So under 21.3, it is perfectly possible for APW to say, but there may be a public benefit for having this electronic communications apparatus here, but they've not been paying for it. I am being severely prejudiced as a result of it, and as a result of that, you should not make this code order. There are, I was going to deal with this slightly later, my lord, but there are other reasons why with the non-payment of rent that it doesn't create the problem that my learned friend suggests. The first is that Gencomp, although it's not the party receiving the rent, it still is in a position, we say, to be able to turn around and say, well, we want to terminate this agreement because our concurrent lessee is, there's a joint obligation under the 1995 Act. Although we can't receive the rent, the problem of non-payment of rent is still being generated, and we want to rely upon this provision in order to terminate it so that our concurrent lessee does not suffer any further problems. So
what commercial incentive would Gencomp have to do that?
Well, it would depend upon obviously what the terms in the in the concurrent lease actually were. I mean, in a lot of leases, for example, there would be a duty to cooperate in achieving.
Really?
Well,
I mean, I haven't studied the concurrent lease in great detail, but it looked at first glance to be a perfectly simple demise of premises for a term, passing the right to the rent to the lessee, and the freeholder then gets paid a substantial premium for it. But it's effectively a financial transaction under which you give me a capital sum and I'll give you the rent for the rest of the term. But it's not an ongoing relationship in terms of we're going to cooperate to achieve particular ends.
No, I would agree with that, my lord, and obviously it is feasible, possible for concurrent lessors to turn around and say, we're not really interested in this is your problem, you go ahead and deal with it. But
I thought Gencomp, I mean, again, we're looking at the facts of this particular case, but I thought Gencomp's position was, as you might expect a person in their position to be, well, we've passed this problem to you for the next 40 years. It's up to you to sort it out. We'll do whatever's necessary, but we don't want to take commercial risks or get involved in litigation.
No, but it would be possible, for example, for APW to indemnify them and indeed take it over. It's not in our respectful submission such a huge problem as it may seem, because there are lots of circumstances where effectively APW has taken over the running of cases from other parties.
Well, I'm not sure, if I may say so, that this really fits the grounds of opposition. If you go to 31.4b, deals with non-payment, delays in payment. Code agreement ought to come to an end because of persistent delays by the operator in making payments to the site provider under the agreement. Now, you may say, well, the site provider in 4b is not the same as the site provider in 31.1, but that would be a slightly odd interpretation. Here, the rent is or ought to be paid to the concurrent lessee, and so there's no delay in paying rent to Gencomp on these facts because no rent is payable. And anyway, you've got this ought to come to an end, and the operator would say to Gencomp, well, there's no skin off your nose if I don't pay the rent. You're not entitled to it.
Well, I understand the logic of where your lordship's going on this, but the key point we would say is, of course, that even though it is fully accepted that the operator should be paying its rent to APW, not to Gencomp, it doesn't mean that there doesn't still remain a residual obligation, which obviously they would be stopped from claiming rent from APW. But Gencomp can say, under the terms of Section 15 of the 1995 Act, that is an obligation still owed to us as well, and that therefore, if you are not paying the rent, we are entitled to raise this as a reason under paragraph 31 to do it.
So non-payment of rent to APW, which you accept as the person who has the right to receive rent,
Yes.
is a breach of an obligation to Gencomp.
Yes, albeit that obviously the party who would be most interested in that obligation would be APW, because they're the ones who want the money. But it doesn't prevent there being a legal route by which Gencomp can say there is and remains an obligation under the 1995 Act because the obligations are coterminous, and you are not fulfilling that obligation. But in any event, my lord, we'd say that if there was non-payment of rent, it still would be capable of satisfying paragraph 31(4)(a), which provides that the code ought to come to an end as a result of substantial breaches by the operator of its obligations under the agreement. And clearly, if it's not paying rent, that is one of the obligations under the agreement it's not meeting. And so Gencomp, on any view, could rely upon the non-payment of rent as a reason for terminating under paragraph 31(4)(a).
I may be being a bit slow here down the pace, but what is the? Can you explain to me if the code agreement is purely contractual, on what basis do you accept you're obliged to pay APW?
Well, my lord, the problem comes, in our respectful submission, from the fact that you're looking at two different obligations on the operator. So the operator obviously has the obligations under the code agreement that it has entered. We accept that. And that is the primary contractual obligation that your lordship's referring to. However, obviously in the situation of privity estate and on landlord and tenant law, the position is, and we accept this, that we would owe an obligation to APW to pay rent. And that would be under section 15 in any event of the Act.
Yes. Do we have the 1995?
Yes, my lord. It's in the Second Authorities bundle at tab 18, I think it is.
Thank you.
Page 364.
And is your answer to my lord's question the same, whether Vodafone has a lease or a license?
Well, my lord, under a license, of course, there is no. Sorry, my lord, I didn't catch. Who has the license?
Vodafone.
Vodafone.
I think my lord's question was directed to
Yes.
a purely contractual arrangement,
Yes.
i.e., a license to Vodafone.
Yes.
And then, how does APW become entitled to receive the payments under
Yes.
that license?
And the answer is they don't. So in that particular instance, the payment of rent to APW would not happen. It would still be going, or not rent, consideration, it would still be going to Gencomp.
Is that right? So you have a freeholder, Gencomp, grants a contractual license, not a lease, to Vodafone, under which payments are made at an annual rate, say £1,000 a year. Gencomp then leases the land to APW.
Yes.
Now we know that were it not for the code, the license, that gives APW the right to possession, prima facie, of the building. We know that were it not for the code, the license, being a mere contractual license, wouldn't bind APW, so they'd be entitled to possession. But the code continues the license so as to bind APW, because under 10.3b, APW is somebody whose interest in land is derived from Gencomp's. So we know that the license is now binding on APW, so they're not entitled to possession as against Vodafone, despite being the tenant at the bottom of the chain. Are they not entitled to the £1,000 a year, or is that still payable to
No,
Gencomp?
that's still payable to Gencomp in that particular example, because the APW have never become a party to the code agreement. It is only through the doctrine of privity of estate, and this is a core point we say when one's looking at how you should interpret the code, that the real problem is that APW's solution might work where there's a lease from the point of view.
Yeah, you said this yesterday.
Yes.
And I just wanted to be sure that I had understood.
Yes, and I hope that working through that example is giving your lordship the information that your lordship wants. That basically the payment of rent or consideration, the payment of consideration still goes to Gencomp under the terms of a personal license. Now, it may be that there is an attempt to ensure that there's a discharge by paying to APW, but Gencomp would have to consent to that in something or other. There would have to be something of ovation of the arrangement so that the payment crosses. My Lord, I'm sorry, when I was answering your question, I was looking at it in the context of there being a lease as well, and that creating effectively the obligations under section 15.
It seemed to me your answers, which were addressing your submissions, which were addressing how structure works, were all predicated on the basis that APW had a right to the rent.
Yes.
Because it has a lease.
Yes. Because there is a lease between Gencomp and the operator.
Yeah.
That is the core to it. As soon as one makes the relationship between Gencomp and the operator a license rather than a lease, then of course all of APW's arguments completely break down. And that's the point I was making about partial solutions should not dictate the meaning of the code.
And presumably, do you say that when a lessee takes a concurrent lease, subject to existing rights, contractual or otherwise, and particularly if it's part of its business, in any event, part of what you'd expect it to do was to ensure that it wouldn't subsequently be in difficulty with those rights, and so it would make provisions, ensure that there were sufficient provisions made one way or another, that it wasn't ending up in a position where it had the burden but not the benefit.
Yes, exactly, my lord.
Just like anyone taking a lease, it has to ensure that any rights that they take subject to are not going to be burdensome, or in a way that they can't be compensated for.
Absolutely, my lord. And this comes back to one of our central points. The problem here is the mechanism that APW have used to interpose themselves into the code agreement. If they had stood back and actually looked at the code in more detail when they were setting this up, because of course by the time that they had the grant of this concurrent lease, the code was already in place. They knew full well what the terms or the language of the code actually was, even if they didn't necessarily understand fully the consequences. But if they had set the mechanism up in a different way, then they would be in a much, much stronger position in order to deal with the problems that they say that they suffer. The answer is that they are suffering these problems as a result of the legal mechanism that they have actually employed.
So what legal mechanism could they have employed which wouldn't involve these same problems?
Well, my lord, firstly, they could have a very clear clause saying that in the event of the operator not paying the rent, the
Gencomp would terminate.
Gencomp would terminate.
Indemnity.
Yes, and there's all sorts of provisions like that could be built in, and it's one of the points that the Upper Tribunal was keen to emphasise in the judgment. That now we know what the position is. Parties can contract and organise their arrangements when concurrent leases are being used in order to ensure that the problems that might be thrown up are not thrown up. Ultimately, it comes down to how parties structure their deals. And unfortunately for APW, we say, they haven't structured it in the way that they would like it to be structured. But that is not a reason, in our respectful submission, for changing the otherwise clear language of the code.
You say we're being asked to do serious violence to the clear structure in order to put right the problems which have arisen due to APW's failures to anticipate these issues.
Exactly, my lord. And it is of considerable note that APW has been involved in a series of reported cases already. I think it's 4 reported cases already, where they've been arguing with operators over their rights. Not once has a developer of a major project applied to come before the court and saying the operators are behaving unreasonably. And we say there's a very clear reason for that, which is the operators are not only subject to the code rights, they're also regulated
Yes,
by
you made
Ofcom.
that point yesterday.
I don't think we can form any view as to what the reaction of the regulator might be if you fail to pay rent under the code agreement. I mean, you no doubt want to tell us that you behave reasonably because you're reasonable people and you're regulated, but we can't decide this case on the basis of how reasonable you're likely to be.
No,
we have to decide it on the basis of what the structure of the code is and how it works.
But in assessing the structure of the code, one has to take into account that regulation was in the mind of the government when it was actually drafting the code. And can I just show you that point?
You need a direction from Ofcom in order for the code to apply at all.
Well, it has to apply at all, but there is a specific point in the in the statement from the Department of Culture, Media and Sport, as it then was, which can be found in the authorities bundle at tab 33. And there was a considerable discussion about what land constituted, how the definition of land was being constituted, because what was being said was that, well, if you include electronic communications apparatus in the definition of land, it would allow operators to be able to obtain code rights over, for example, somebody else's mast. So if you've already got a mast,
piggyback on someone else's.
Yes, piggyback on someone else's. And there was obviously a concern with the the operators that in fact it might be used as a method for effectively shutting them out from being able to get on mast, because people say, well, it's not land under the code, therefore the code does not apply, therefore we can charge whatever rents we actually want to. And this point was considered at page 542. So here we see the government's response on the definition of land. Government's carefully considered all the views expressed. Stakeholders have an opportunity to work together and put forward industry-led solutions. No solution put forward. The government has fully considered the consultation responses along further representations. There are 3 key points of consideration. First, the recognition of a range of options given the definition of land. Then it considers that the original purpose of the code was to provide a legislative framework to enable access to land for the siting of communications infrastructure, not to enable access to infrastructure itself. And so the basic rationale for the code has not changed. And then one sees in the 3rd bullet point, the government is clear that a legislative framework already exists for gaining access to communications infrastructure should the market fail to prove this on a competitive basis. The EU Access Directive, implemented by the UK Communications Act 2003, provides a basis for regulated access to electronic communications infrastructure, including in cases of significant market power. It is monitored and enforced by Ofcom, and no case relating to third-party provision of passive infrastructure has to date been brought to the infrastructure. So regulation was something well in the mind of the government when it constructed this code. And we say one is entitled to have regard to the fact that there is regulation and that regulation is a solution.
This is about about network sharing, isn't it?
This is about network.
It's not about the relationship between the operator and the landowner. It's about competition in the telecom sector.
Yes. Your Lordship, the difficulty is that the common regulatory framework, as was, covered a large area of issues. The primary issue was about competition and ensuring that competition existed, and the powers were generally given to the national regulatory authority, in this country obviously Ofcom. That common regulatory framework still exists as a purpose behind the instigation of the Communications Act 2003, and we say the code itself, because even though the UK may now have left the EU, at the time the code was implemented, the UK government was still bound to comply with the EU directives, and indeed the directives which are relevant relate back to 2009, which were not in any shape or form at that stage underpinning or to be ignored when construing the 2003 Act. But in the course of all the proposed regulations about competition that was included, one of the specific measures that was implemented was Article 11 of was the Framework Directive, amended by the Better Regulation Directive, and now is encompassed in something called the European Electronic Communications Code. But if one just concentrates on the position at the date the code was implemented, there was a very clear directive from the EU that processes must be in place to ensure that the access to land was being granted to operators. And if I can just ask you very briefly, because this is an immensely complicated subject, which unfortunately I spent quite a lot of time in the Competition Appeal Tribunal discussing at length, and I want to try and keep this as short as possible. But if one goes to tab 24 and goes to page 466.
446?
466.
466, yeah.
One sees Article 11 of the Framework Directive as it was amended by the Better Regulation Directive in 2009, dealing with rights of way, and that member states shall ensure that when a competent authority considers an application for the granting of rights to install facilities on, over or under public or private property to an undertaking authorised to provide public communications network, or an application granting rights to install on public property, the competent authority acts on the basis of simple, efficient, transparent and publicly available procedures, applied without discrimination, without delay, and in any event makes its decision within 6 months of the application. And that, of course, is why all code cases have to be dealt with by the Upper Tribunal within 6 months. There's a specific regulation that has been introduced to...
So the competent authority includes the Upper Tribunal? It's not
Yes.
just off court?
Yes, yes. And in construing...
Does your twin track solution of part 4 and 5 meet the criterion of simple procedures?
Well, my lord, it obviously is an issue that's arisen as a result of the Compton-Beecham decision. It would be possible for, and indeed, up until the whole of the Compton-Beecham problem arose, a lot of operators had just gone for a code agreement straight under Part 4 rather than using Part 5. But now they've all moved away from that because of what was being said about Compton-Beecham. But what we do say, and what is absolutely crucial about simplified policies, is that one shouldn't then have to have recourse to various different bodies of corporate law, of landlord and tenant law, in order to assess whether in a particular situation the code means this or the code means that. And that's why we mentioned this. And we particularly, the reason why this is in the bundle is it relates to the paragraph 16 argument that Malone Friends put forward. And we say, well, when one looks at this, and particularly the directives that, the recitals that precede it, that it's quite clear that in fact there must be a way for operators to become assignee operators to become parties to the code agreement, because it otherwise would be completely inconsistent with this. Perhaps for good measure I should just refer you to recital 42 of the Better Direction Regulative, which is at page 463 in the bundle. This, as I'm sure your lordships are aware, with most of the EU directives, they have a series of recitals which are important in construing the effect of the directive itself. Paragraph 42 deals specifically with what ends up in in Article 11. And so permits issued to undertakings providing electronic communications networks and allowing them to gain access to public or private property are essential factors for the establishment of electronic communications networks or new network elements. Unnecessary complexity and delay in the procedures for granting code rights or ways may therefore represent important obstacles to the development of competition. So I accept your Lordship's initial point that all of this came about because of competition concerns, but in Article 11 there was a specific provision relating to the system that should be developed.
Rights of ways. It's not just about rights of way, is it? It's rights of installing and maintaining ECA.
Absolutely, but I think, and the trouble is it's not in the bundle. When one looks earlier on at some of the earlier material, particularly the material contained in the original framework directive, it is made clear that rights of way are discussing the keeping of electronic communication apparatus on land. So I don't think there's any dispute that rights of way has a narrower meaning. Now, as I say, the only reason why that material is primarily in the bundle is because it deals with a point that we were raising on paragraph 16, to say, well, it's obvious that an assignee operator must be in a position to be a party to the code agreement. But I understand from a learned friend he's not really disputing that. And his answer to this is, well, this shows again that leases must give the answer to the solution, privity of estate. Again, that argument completely breaks down when one takes my Lordship's example of contractual licenses, because that does not solve the problem. The problem has to be solved from the language itself, which we say is actually patently clear in any event. But
Sorry, I haven't quite understood this paragraph 16 point. Paragraph 16 is about assignment of code rights.
Yes.
I have to point that it has to apply whether the code rights are granted by way of a lease or by way of a license. I haven't understood quite what your submission is, or indeed what the dispute between you, if any, is. I thought the point Mr. Clark made was that it doesn't expressly say the assignee becomes a party to the agreement. What it expressly says is the assignee is bound by the agreement. That's 16.4.
Yes.
But it must be implicit that the assignee becomes a party to the agreement, because it's the assignee who then wants to have all the rights under Part 5 and so on and so forth.
I think that was the point that came out from yesterday.
Well, that was what I understood the point on Part 16 to be.
Yes.
In paragraph 16. Now, I haven't understood what your current submission is on the basis of that.
Well, my position is that if one is looking on the general principles of assignment of rights, whether they be whether they be licenses or whether they be leases, the critical reason why one doesn't become bound. Take the example of the contractual license. Yeah. So, in other words, the tenant has given a license to the operator to access to the roof. In that situation, the point being made by my learned friend, as I understand it, is that they may get the benefit of any assignment, but they don't necessarily bound by it. And the reason why that is relevant is because under contract law, one if the obligation is owed to you by the assignor, you cannot therefore have that obligation being taken over by the assignee without some form of consent by yourself. Now, what we say is that that fundamental objection, which one can see, for example, in Chitty in the passages that are actually within the bundle, that objection does not apply once you have a specific provision relating to somebody being bound by the agreement. The logical consequence of having a provision saying in terms that they are bound in this situation and why they're bound means that necessarily the agreement must have transferred. Now, that is slightly different from, obviously...
I thought what you were saying was that it is implicit in paragraph 16 that the assignee who is bound by the agreement upon assignment becomes a party to the
Exactly,
code
my lord. Exactly. Sorry, my lord, if I hadn't put that.
for the purposes, amongst others, of paragraph 31.
Yes.
And
That's
I understood that to be common ground between you. I think.
Yes, and I think it is after yesterday's.
So I have not quite understood what the point on paragraph 16. What is the point that you want us to take from paragraph 16, which assists the argument generally? I'm sorry to be so slow.
I suppose I'm putting a negative because I'm saying that any arguments based on paragraph 16 simply don't help you on paragraph 10. And there's very good reason for that, because paragraph 10 is dealing with a completely different situation. It's dealing with the relationship between it's dealing with site providers. Paragraph 16, in a completely different part of the Act, of the Code, is dealing with operators' positions. So paragraph 16 has nothing to do, we say, with the construction of paragraph 10. But my learned friend was relying on it in his skeleton argument to say that actually you can see that this must mean that paragraph 10 has to be read in a different way.
Well, forgive me if I misunderstood. I thought the point that was being made was, look at paragraph 16. It does not in turn say an assignee becomes a party to the agreement. It's common ground that an assignee does become a party to the agreement. I don't, at the moment, understand there to be any real difference between you as to why that's common ground. It's common ground that 16.4 makes the assignee bound by the terms of the license, and the general law entitles the assignor to assign the benefit to the assignee. Therefore, the assignee is both bound by and has the benefit of the agreement, and in those circumstances, its common ground must be treated as a party to the agreement for the purposes of Part 5. And,
Yes.
All that, I think, is not in dispute.
Yeah.
So the only, well, I think the only point that's in dispute is, does that tell you anything about how exhaustive the code is? And Mr. Clark's point is, well, it doesn't. It shows the code's not completely exhaustive, because here's an example of someone who has the benefit and the burden of a license, who is a party to the agreement without the code expressly saying so. And I think you agree on that.
Well, we agree that it does not use the specific language that a operator becomes a party to the agreement, but we say, it is fair to say, I may be tilting at windmills slightly at this, because my learned friend, when he was discussing it in his skeleton argument, did not make the point as clearly as he is saying now, that in fact he accepts that an operator must be bound must be a party to the agreement in all circumstances. So now that we're on common ground, I think that there isn't much.
There isn't a paragraph 16 point at all.
There isn't a paragraph 16 point at all. But what we say is you can't use paragraph 16 to have to apply it to a completely different paragraph dealing in a different part of the Act, dealing with completely different situations.
Well, I thought the point Mr. Clark was making was, given that's what, it's not really disputed, the effect of paragraph 16 is with assignees of the operator, the assignees of the operator. Similarly, or by analogy, where you have someone like APW who is bound under the code, paragraph 10.3b, I think, but also has the benefit of the covenants, see section 15 of the 1995 Act, in exactly the same way. They're bound, they've got the burden, they've got the benefit. Why are they also not a party to the agreement? That's what I thought the point was.
Well,
I may have misunderstood, but if that is the point,
I think that's the point, as it certainly was developed yesterday.
yes.
And so that's
what
the
is
thing I will deal with.
that? So,
And the reason why I say that still doesn't hold good water is, firstly, they are different parts of the code. It's a very different structure. Therefore, there's no logical reason why, how one approaches paragraph 16 in part 3, one should apply the same approach in paragraph 10 of part 2. But the second point is that it draws a false analogy that of 10.2b, which is the binding provision, with what happens with an exchange under an operator. Because going back to the contractual license example, the obligations that the operator owes will be owed to the freeholder, if one likes, rather than the tenant. If you have a relationship of freeholder and tenant interposed after the license code agreement has been put forward, then, my lord, it still doesn't assist you, because although the tenant will be bound, it certainly isn't able to receive the benefit of it. Whereas under 16, clearly the operator does receive the benefit of it. The assignee.
It's a very odd situation, isn't it? That if there is a contractual arrangement, then somebody can be bound by it but not entitled to take the benefit of it. Not complain, for instance, that the operator is causing damage to the building or whatever it happens to be.
Well, unfortunately, my lord, this all goes back to the focus on the occupier.
Yes.
And I think the trouble is that we are now at a point in time where it is no longer possible to argue that anyone other than the occupier could confer code rights. I personally am not entirely convinced that that was the position under the old code, but anyway, I think there is sufficient authority against that. And that is the problem, that as soon as you concentrate on a person conferring code rights, one rather takes the ball off what happens with parties being bound.
But do you accept that we are urged by Compton Beecham to make the code work in the way it was intended to work?
Well, my lord, I don't accept that, and perhaps I can just very briefly make my reasons why I don't accept that. So as we know, the starting point was that the occupier was not considered to have a fixed meaning in that case.
Yeah.
And that there was strong authority that where he didn't have a single precise meaning in all circumstances. So that meant the Supreme Court had to consider its meaning in the context of the purpose of the code. And that required an assessment of the purpose. And it's quite clear what the purpose was the rollout of infrastructure and to enable long-term investment of digital communications. That was the purpose, and the one that drove the decision of the Supreme Court in the House of Lords. However, the construction that APW were contending for in the Supreme Court, namely that an operator in situ must always be treated as a occupier for the purposes of paragraph 9 of the code, that would have had catastrophic consequences for the rollout of infrastructure and investment, because as we know, it would have led to the operator being unable to obtain new code rights, the code rights and therefore equipment and upgrades, etc., would all have been frozen to those at the beginning. That would have been completely contrary to the purpose of stimulating proper rollout of investment and so on and so forth. That in turn would lead code operators asking for the kitchen sink when they started off with their initial code agreement to try and cover all possibilities in the future. And that in turn would lead to even more difficult consequences, and the code operators might be charged far more than they needed to, simply to future-proof the agreement. And it would also lead to bizarre consequences like the wasteful and pointless expense of moving off the land and then moving back again. And all of those points one sees very clearly in the passages that I took you through in Compton Beecham yesterday. In contrast, in this case, one asks, does the Upper Tribunal's construction of the code affect the rollout of infrastructure and enable long-term investment of digital communications? And we say the answer is clearly no. That actually it's perfectly possible to accept the construction, the Upper Tribunal's construction of the code, and that will not in any way prevent the underlying purpose of the code going ahead. So there's a very clear distinction between what was the methodology for ending up with the decision in Compton Beecham and the position here. And perhaps I can give one example of it. The issue of successors in title to that interest has obviously been raised by my learned friend in his argument and saying, well, that shouldn't be given a normal meaning, etc., etc. It should be given a more extended meaning to allow constituencies like him to be included in it. one asks the question, well, suppose the Upper Tribunal's decision on that particular point is upheld, how does that affect the purpose of the code? And we say, not one jot. It won't prevent the rollout of infrastructure. It won't prevent...
Yeah, no, you say the Upper Tribunal's construction serves the purposes of the code.
Yes. And that links into the point I've obviously made at some length, that one should be very, very, very wary of construing the code in order to deal with outlier situations.
Yeah, no, you've made that point.
Do you agree with Mr. Clark that the likelihood is that the drafter of the code simply didn't think about concurrent leases at all?
I suspect it certainly wasn't at the forefront of his mind, but the reality is I think, I would submit, that what he was trying to do was to cover a whole series of possibly very different situations, tree lopping, licenses, so on and so forth, and that he just tried to derive a code that actually at least covered the majority, the vast majority of those situations, and that what he wasn't, the hypothetical draftsman, interested in was looking at all the outlier situations. And when one comes to it, my lord, one needs to be very clear what the purpose is before one can start applying purposive constructions. I don't know whether you want me to take you to an authority on that point, but it's quite clear that perhaps I should, because it's the Pollen Estates authority that my learned friend has.
Well, you say the purpose of the code is to facilitate the rollout of electronic communications apparatus and to encourage investment in that apparatus. That's it. That's the whole
yes,
purpose.
yes, yes.
Yeah. Right, want us to look at Pollen?
Well, there's only one paragraph. So if I can ask you perhaps very briefly to look at it. It's Authorities Bundle 1, tab 8, page 167 in the bundle. My lord, this was a revenue case, and it basically turned on the construction of a revenue provision in the Finance Act.
Yeah, sorry, which page?
And if one goes to paragraph 25, well, 24 starts the approach to construction.
Yes.
And 25 sets out Lord Nichols of Birkenhead's dicta, where he's effectively making the point that one must be very careful about crossing the boundary between construction and effectively the court legislating. And he sets out various reasons that courts exercise considerable caution before adding or omitting or substituting words. Before interpreting a statute in this way, the court must be abundantly sure of three matters: the intended purpose of the statute or provision, two, that by inadvertence draftsman and Parliament failed to give effect to that purpose, and the substance of the provision would have made, although not necessarily the precise words Parliament would have used, had an error in the bill been noticed. So in our respectful submission, although obviously the courts can have regard to the purpose behind it, that purpose is not the one that really assists my learned friend. And in any event, one needs to be very careful not to try and effectively legislate to improve the code if the language of the code is clear. And that's really the only point that I wanted to make on that case. Can I then deal directly with the asymmetry argument that my learned friend put forward? We find it slightly a surprising argument to come, because it was specifically APW's choice to effectively intermeddle in the code by use of the concurrent lease. And one might therefore have expected that, having got itself so interposed, the last thing it would want to do would be to end it. So there is a sort of slight irony about the way that my learned friend relies on this idea that only the operator can terminate the agreement.
Or increase the rent.
Or increase, and that's the point I specifically want to deal with, my lord.
And that seems to me a much bigger point.
Yes, because
against you.
we, this is a point that really is a complete non-point in our respectful submission. And indeed, one felt that Mr. Clark's submission that there hadn't been a rent review since 2013 under the existing code agreement might have been made a little bit tongue-in-cheek. The reason we say that was because they would have known full well in any event that there could not be any further rent reviews under the existing agreement. But more to the point, they would also know full well that the rent payable under that existing agreement, even if it had been fixed in 2013, will be significantly higher than what they will get under a new code agreement.
Well, that's specific to these facts, but you take the grant of an overriding lease for 125 years of a block of flats, and there's a 15-year agreement with an operator. You would not be able to, the overriding lessee would not be able to increase the rent for 100 years.
Well, my lord, that obviously depends upon whether the other routes were available to, for example, the concurrent lessor, going back to the structuring of the agreement. But certainly, in those situations, it is very likely that the code, the rent fixed under the pre-new code agreement will, even after 100 years, still be nowhere near what would be payable under.
Well, suppose it's an existing agreement under the code, where at the no network rent, and there is then.
Well, that would have to be you'd have to postulate an agreement that was first entered into in 2009.
Yes, I know, but we're talking about the structure of the code, not these particular facts. And if that were to happen, so there's a code agreement under this code in place at a no network rent, and an overriding lease of the roof of a block of flats is granted for 125 years, and there's serious inflation for 50 years, the lessee on your analysis can't do anything about it. The operator can just sit there and say, well, that's good. Nobody can do anything. Nobody can stop me.
Well, you would have to ask the question of whether or not the lease itself, the lease between the freeholder and the operator, whether it didn't have a provision for rent renewal in any event. Their presupposition is that because this is an agreement that was coming to the end of its life, the rent review should have taken place in 2013, but there was no provision for any rent review thereafter. Therefore, they are stuck with that rent. But if you had a new agreement, it would undoubtedly have rent review provisions in it in order to deal with
But APW can't require you to enter into a new agreement under Part 4 because it doesn't apply. They don't have the right. They can't initiate the process. Only the operator can.
Well, my lord, one is, I would respectfully submit, looking at a fleetingly small number of potential cases, because one would have to presuppose that the new code agreement was entered into in 2019. There's a whole raft of reasons why that didn't necessarily happen, because parties were still feeling their way through the provisions, and in particular the rent provisions under the new code, which were really only...
No, but you're concentrating too much on a particular set of facts.
But my lord, the other point that I was going to make is that, of course, as soon as the decision of the Upper Tribunal is in hand, then parties know where they actually stand on this matter and how they need to address it in structuring their dealings thereafter, which is the point that the Upper Tribunal made. So, my lord, one is... this is being urged on you as a real concern under the code, and our point is that in reality it is not a real concern, because most of these leases the operator will be absolutely as keen as mustard to break them and get a new lease as soon as possible.
To get the no scheme rent.
Yes, well, perhaps I can just take you to one of the authorities, which is in the second authorities bundle right at the start at tab 13. Which is a decision of this court on Tower. It's page 272.
Sorry, which tab? 13.
13,
Yeah.
page 272.
Was this one of the ones which went with Compton Beecham to the Supreme Court?
No.
It's a different on Tower.
It's yet a different strand of authority on this point. This one concerned a renewal under Part 5 and how that should be dealt with because the critical issue was the terms on which the new agreement should be granted, including the rights to upgrade and share. And just so your lordships know that one of the ways that under the old code, landowners, site providers actually extracted additional rent is because they basically said you could have 4 antennae on the site, and if you wanted to have any more, you had a serious problem because you'd have to go back and negotiate an uplift in the payment to do that. And sharing was likewise. So there was a serious issue financially on what would happen with these codes. And the respondents sought to argue that the rights should be confined to those in the existing code agreement because, for example, that is what the 1954 Act would expect, and the code was similar to and modelled on the 1954 Act. So it goes back to the point my learned friend was making about the Law Commission's recommendations. If I can take you to paragraph 40 in the judgment at page 281, one can see where paragraphs 40 and 41, you can see the argument. And Mr. Piermont, who again was appearing for the site provider in that case, argued that this wording is similar to and modelled on that to be found in section 35 of the Landlord and Tenant Act, and it must be construed in a similar fashion. Mr. Paragraph 44, you can see that in making that submission, Mr. Piermont was relying heavily on the Law Commission's paragraphs, and I think that was one of the ones that my learned friend referred to yesterday from the Law Commission's statement. And then at paragraph 45, there's reference to the Court of Appeal decision in Cornerstone and Telecommunications, which I think the reason why that was referred to occurs later in the judgment. So if I can take you to paragraph 46, Mr. Piermont stressed the reference to paragraph 3412 of the Code with section 35 of the Landlord and Tenant Act alike, making the same terms of the existing tenancy agreement the starting point. However, in Stevenson, Mr. Justice Fancourt was cautious about comparisons between paragraph 3412 of the Code and 35 of the 1954 Act. And you can see then paragraph 53 is quoted where he makes the point that the provisions of the Code are not in any respect exactly the same as those in Part 2 of the 1954 Act, and was careful not to read too much based on the superficial similarity of structural language. The purpose underlying the 1954 Act was very different from the Code to protect tenants and business tenancies from excessive cost, business interruption and loss of goodwill by providing security of tenure, while the legitimate interests of the landlords in recovering possession and receiving payment of a market rent. The purpose under the Code is to ensure that operators can use and exploit sites more flexibly, quickly and cheaply than had previously been the case, at lower than open market rents, in furtherance of the public interest of providing access to the choice of high quality electronic communications networks and so on and so forth. So again, the very clear purpose is set out, and one of the reasons why operators are so keen to have new agreements is precisely to give them that flexibility which the Code was intended to achieve. And then one can see at paragraph 55, Mr. Justice Fancourt making one of the objectives of the Code was to change the terms that apply to Code agreements where they restrict operators from doing or having the flexibility to do what they reasonably need to do, or where they operate against public interest. In the Code, there is therefore not the same generally applied presumption against change that has been read into the language of section 35 of the 54 Act. Rather, site providers are required to put up with a degree of change in the public interest for facilitating provision of the choice of high quality networks. And so we then see at paragraph 58 on the following page that Mr. Justice Fancourt specifically rejected a read across of the principles in O'May into the Code and obviously that was one of the points that are being picked up in the Court of Appeal in Compton Beecham. He concludes by, I reject the argument as part of the ratio of Ashlock, the paragraph 3412, sorry, I said Compton Beecham, I meant the Ashlock case. The paragraph 3412 of the Code has the same meaning in effect as section 35 of the Act. And then at paragraph 47, the Court of Appeal made quite clear that they accepted what Mr. Justice Fancourt had agreed and concluded that the Code cannot be said to be aiming to protect site providers in a similar way. To the contrary, as Fancourt J pointed out, the Code seeks to enable operators to use and exploit sites more flexibly, quickly and cheaply than had previously been the case. So, my Lord, I refer you to that case for two reasons. The first is to make the point that where one has existing agreements, it is almost invariable that it's the operator that will want to end it. And to the contrary, those like APW who are sitting on old code rents will want them to continue for as long as they possibly can and also maximise their returns. And the second point I do want to make out of that case is really to deal with my learned friend's suggestion, which he raised, I think, specifically in respect of Part 5 yesterday, was that one should have very clear regard to landlord and tenant law, because the Code had to some degree been modelled on landlord and tenant principles, whereas one can see with that judgment that that's absolutely not regarded as the purpose behind the Code, and so one can't read across from landlord and tenant principles into the Code. And we say that must be, if that's the case for Part 5, which clearly was modelled to a degree on the 1954 Act, that must be a fortiori when one's looking at the earlier provisions, where there was no indication at all that they were being modelled on any specific landlord and tenant problem. And the Lord, I think that I've already made the point, but I'll just reinforce it again. That again, once this problem is settled.
Yes, you've made this point. You don't need to make it more than once.
Can I ask you another question arising out of that? As you've just made clear to us, that the original grant by, well, it was Gencomp's predecessor to Vodafone was under the old Code. I assume, I mean, neither party I think is referred to us, but I assume there are transitional provisions which carry that through into the new Code in some way.
Yes.
Do we need to bother ourselves with those?
I think probably not. The reason is I think Mr. Clark sort of touched on it yesterday.
It was a subsisting agreement, therefore it took effect as an agreement under Part 4. 2. Yeah.
Yes, that's right.
Do we need to know any more than that?
I think probably not, but just for your reference, if you want to just very, very briefly look at it, it's contained in tab. These have been included.
It's in there, yes.
Yes, I'm just trying to find the. Yes, it's tab. So it's tab 23 at page 452 in the authorities bundle.
What is?
The transitional provisions.
And it's paragraph 2. Subsisting agreement has effect as an agreement under Part 2.
Yes, but paragraph 1, 2 of the schedule. And then if one goes on, one sees paragraph 2, a general indicator that the subsisting agreement has effect after the new code comes into force as an agreement under Part 2 of the new code between the same parties, subject to the modifications of this schedule. You'll see that page 453 in the bundle. And one of the key differences, well, there are a number of key differences, but one of them is that where there is a 54 Act lease, and one can see this at paragraph 6 on 459A. So it's effectively what happens is that if Part 5 is applying, then the provisions don't, under Part 5, don't apply to the Act. So one has to read paragraph 6 in order to see that it's dealing with Part 2 of the Landlord and Tenant Act, and then in paragraph 7 there's an exclusion. And likewise, if one goes back slightly, the rules on assignment are actually disentailed from subsisting agreements. So if one looks at paragraph 5 on page 456, paragraph 16 of the new code, assignment of code rights, does not apply in relation to a subsisting agreement. So essentially what happens is that Schedule 2 of the 2017 Act makes, for the most part, a subsisting agreement subject to all of Part 2 and various of the other provisions of the Act, but it specifically disapplies it in various situations. I hope that answers my lordship's question.
Thank you.
Can I just add one further point on the alleged inability of...
Sorry, just hold on a minute. Vodafone has a subsisting agreement,
Yes.
right? Which takes effect as an agreement under Part 2.
Yes.
It's that agreement which you seek to renew.
Yes.
But doesn't paragraph 6 say you can't use Part 5 of the new code?
It's where Part 2 of the 1954 Act applies. What it's doing is excluding the duality of the regime.
Yes, quite.
So
Why doesn't the 54 Act apply to Vodafone's lease?
It's excluded.
Because it's been excluded.
Oh, it's excluded.
exempt from
That was addressed by the deputy
Yes, I
president.
forgot that. Yes, I'm sorry.
Sorry, my lord.
Quite.
That was dealt with by the deputy president.
Yes, yes.
Yeah.
Well, Lord, I hope that's answered
Yeah,
all the
no,
questions on
quite
that
right.
point. Can I just deal with the question of redevelopment? Because yes, one can always come up with hypothetical questions where you might say this might be a problem going forward, or it might be a problem with existing concurrent leases. But again, the point I've already made, going forward that's not going to apply. But even here, we say it's not in reality an issue. The only problem that APW might meet about not being a party to the code agreement under paragraph 31 and therefore not being able to serve a notice if it wants to redevelop is if it wanted to develop the site itself for the permitted use in order to use it as a telecom site. And as I've already indicated, that creates with it the problem that they then, if they do that, will be exempt from the provisions on consideration under the code, and they will be able to charge much higher rents than could be charged under the code itself. So the redevelopment of the roof essentially as a telecommunications site really would be a device effectively to circumvent the effect of constraints within the code. And the problem here, and this is a problem that's actually already risen in one of the numerous code cases that's been before the tribunal. The problem here is that when the government was considering this question about land, it's the passage I took you to earlier about whether that should be it should include or exclude electronic communications apparatus. They were looking at it through the prism of regulated parties, wholesale infrastructure providers, who would be code operators and be subject to the same regulation as ordinary operators would be. But of course, the party like APW is not a code operator and is not subject to code rights. I think, my lord, you have my points on the effect of the 1995 Act and that Gencomp still deals with it. And I think also I've also dealt with the question of the non-payment of rent. And I think I've also explored, my lord, the whole issue of, well, even if APW solution were to be applied, it still doesn't assist where the agreement between the code operator and the as a license rather than a lease. So
Yeah.
I don't think I need to go any further about that.
Can I ask you one question which was touched on yesterday? If Mr. Clark is right and APW is a party to the agreement, is your position that Gencomp is also a party to the agreement, or do you not have a position?
Well, my lord, that's the only logical way one can look at it. And this is if I can put it like this, a real problem in the way that APW are putting this case, because I know...
What would be the problem? I mean, suppose Mr. Clark were right, and APW, because of the 95 Act, becomes a party to the agreement, but you say Gencomp, which is also under the 1995 Act, still entitled to the benefit of the covenants, remains a party to the agreement. Why do you not just then operate Part 5 against both of them?
Well, my lord, that will create tensions that will again have to be resolved. Firstly, there's a question of so if one wants, for example, for Gencomp to redevelop the site, and they apply under paragraph 31, APW may well say, oh no, we don't actually want the code agreement broken because that's again contrary to our interests. And so you would have a whole raft of issues as to whether you needed to have a joint notice served by Gencomp and APW, or whether or not you could have a one by Gencomp, and what is APW's standing in that to object if Gencomp falls within.
But doesn't that problem arise on your proposed solution, which is simultaneous applications under Part 4 and Part 5? You've still got the potential for conflicts of interest between holders of different tiers of interest in the land.
But there won't be the problems that one faces of how exactly it's. I mean, if we apply, so one has to assume that we're talking about a redevelopment example here. So one has to assume that the starting point for this is that Gencomp wants to redevelop, APW doesn't. Now, as things stand at the moment on our construction, there's no issue. Gencomp simply applies under paragraph 31 subject to any contractual or other restraints that APW can try and impose through the lease that it's actually been granted. What it can't do is come shouting along and say, no, I don't want this because this ruins my interest in the property.
Well, put it the other way around. APW and Vodafone agree a new lease of code rights to Vodafone for 25 years under Part 4. That's the Part 4 application. And on your scenario, Vodafone then apply for Gencomp to be bound by that agreement. And at that point, surely Gencomp can say, no, we don't want to be bound by that agreement. We are proposing to redevelop.
Yes, but
because under the code, the tribunal doesn't have to impose the agreement in the terms which have already been agreed. It can modify it, surely.
Well, the starting point would be that all of this would be before the tribunal as a single whole.
I know, but what you were saying was there'd be all these problems with potential conflicts of interest. And all I'm suggesting to you is that's the nature of the beast, and the procedure, whether it's Part 4 or Part 5, doesn't eliminate that potential for conflicts of interest.
Well, if Gencomp turned around and said we want to redevelop, and that is the reason we don't want it to go ahead, that is their legitimate opportunity under 31.4. We might apply for an order to have conferred rights from Gencomp, from APW, but of course that would be useless until the issue of whether or not Gencomp could break the original agreement was determined. You'd have to determine that first. But it's in the control and the whip hand of Gencomp. If you are saying they are both parties to the agreement under paragraph 31, then if one of them wants to do redevelop and the other one wants to object, how exactly is that to be worked through? It may be an issue for another case, but it shows that the consequences in our respectful submission of trying to make them both a party to the code agreement under paragraph 35 paragraph 33 and 31 is much more complicated than my learned friend would have one believe. And the trouble with all of this, my lord, is that where one has the situation where one party clearly is the party to the code agreement, there is no difficulty. And we say it's the underlying tension in what my learned friend is trying to put forward, because he doesn't really say, well, are we a substituted party or are we a joint party? That question got raised, I think, several times yesterday, and he didn't, certainly from our perspective, answer it clearly. He can't be a substituted party because that would simply run foul of the 1995 Covenants Act. But if he says that they're a joint party, then it does throw up very serious questions about who is the party who can terminate under paragraph 31. I hope that deals with the point.
Would you agree? It seems to me that the core of this code is the simple concept of a contract.
Yes.
It's a contract between an occupier and an operator. And there are provisions as to how the operator can change an assignment, bear with the burden, effectively a novation if notice is given, on the one side. On the other side, you have, if there's an interest in land, the successor in title replaces the occupier. And that's it.
Yes.
Those are the parties to the agreement, and they remain the parties to the agreement throughout.
Yes.
There are then statute provisions as to what that entails,
yes,
and how it might be dealt with by those parties. But that is the structure. You then have the complication that you might have other parties who derive interests from the occupier who need to be bound, because you can't have them in there saying, I'm not bound by this contract. So there's a simple provision saying they're bound. It doesn't say they're parties to the agreement because they're not parties to the agreement. They weren't original parties and nothing would make them parties. And that's it.
yes,
If those parties who take an interest from the occupier, who has an interest, want rights, they need to acquire those rights from the party who has the contractual right, namely the occupier.
yes,
And you say, as I understand it, that's a coherent, sensible structure provided by the code, and if a party intermeddles or intervenes in that structure, they need to ensure that they acquire the rights.
yeah, yes. My lord, I think you've put my argument possibly far more cogently than I've been managing to do it so far.
No, I'm just trying to. It just seems to me these things develop in one's mind, and it seems to me it
Yes.
encapsulates
Yes.
what you've said.
Yes, and of course we say that's consistent, for example, with what Lady Rose said in the Supreme Court about the code being a sui generis statutory set of rules. That yes, that's what it is, and that's the reason why one goes ahead in the manner that your lordship's indicated.
And that's also why, as against the other party to the contract, you apply under Part 5, and why against someone who isn't a party to the contract, you
Yes.
apply under Part 4.
Yes.
And again, that's perfectly straightforward and understandable.
And the law, the reason why it's generated is because of this outlier situation that is unusual, and as your lordship says, that it really is incumbent upon the parties to ensure the legal mechanisms in place to achieve what they want to achieve.
And it also seems to me that there is nothing in the code which would suggest how a contracting party such as Gencomp could cease to become a contracting party.
Yes, my lord, absolutely.
Other than pursuant to the
Yes.
termination provisions or successor in title.
And that's the dichotomy I referred to in my learned friend's argument, that he's saying it's substituting. And how does that happen? And if
So
he's saying,
even if there's a successor in title within paragraph 10(2)(a), there are now two parties.
no,
on
Mark,
that
I
side.
think what is quite clear from 10.2a is then 10.3 in particular is that the party who succeeds the title of the land
Is a substitute or
is a substitute.
Is a
I
substitute.
think in that instance it's clear that he's the substitute, and the reason why is because the other party no longer has the interest in land and so falls away. But I think it's
was a party to the agreement.
was a party to the agreement, but now has ceased to be effectively anything to do with the land, but has a successor in title who is a party to the agreement.
What's the parallel is the operator who was given notice
Yes.
and therefore no longer has any obligations,
Yes, my lord. Exactly.
or is not liable for breach of the obligations.
Yes.
I think is the way it's phrased.
Yes. And we say that this is all consistent with what paragraph 10 is trying to achieve, which is avoiding the need for multiple agreements where possible, and avoiding effectively people intermeddling into the position unless they have managed to structure their arrangements in a way that actually is consistent with it. My lord, I think, well, just bear with me for a moment. My lord, I don't think my learned friend really pressed the arguments on surrender, merger and mortgage in much detail in the arguments, so therefore I won't, unless your lordships wanted to hear anything, deal with that.
I understood them simply to be other practical examples where you get concurrent leases in effect.
Yes, the problem with the examples, though, is that, of course, it all starts from the premise that the freeholder is not bound.
Yeah.
And therein lies the problem. And it goes back to the 10-4 agreement that needs to be in place. And if it isn't in place, the code has solutions for preventing that freeholder from getting the electronic communications apparatus off the site while the occupier is still there. And then even when the occupier's gone, and so he satisfies the conditions under paragraph 37, then there is still the check of paragraph 40 about enforcing the rights, and in particular if the part 4's application has been made. It's the points I was making yesterday. We say that comes to nothing. Can I deal with a point that I don't think occurs in my learned friend's skeleton argument, which is the way the code uses on occasions if and only if. My lord, we say that there are numerous instances in the code where the word if is being used clearly in the sense of if and only if. So the fact that the drafter may have included if and only if in certain instances certainly does not mean that in other instances you should always read if as meaning it doesn't encapsulate everything. And perhaps I can just show you a couple of examples. There are many examples. But if one goes to paragraph 23 of the code on page 424 of the Second Authorities Bundle, tab 21, one sees that I'm just checking my reference. Yes, it's page 424. It is by page 424. So this is dealing with the situation where an application is being made to the court. And it says the operator may apply to the court for an order under this paragraph if. Now, if is used there in the sense of those are the conditions that are met. But if those conditions are not met, it certainly does not mean that one can make the application to the court. So in that sense, it means if and only if.
Well, it says that if and only if.
Sorry, my lord?
You're looking at paragraph 21?
20.
20?
Yeah, sorry, it's page 424, paragraph 23.
20 subparagraph 3.
Oh, I see. Oh, I see.
So the operator may apply to the court for an order under this paragraph if A. And that clearly must mean only if. It can't mean that there might be other instances where one can actually do it. Similarly, at paragraph 33, open brackets, 4 close brackets, at page 439, that point is, so paragraph 33 starts obviously on page 438, And then if one goes over the page, subparagraph 4 on page 439 says subparagraph 5 applies if at the end of the period of 6 months beginning with the day on
I mean, this isn't really the point that was being made, though, is it, by Mr. Clark? I mean, he's not drawing a linguistic distinction of that nature. What he's saying is where the code says that something is a condition, it's quite capable of saying it's a condition. I think he's more contrasting it with paragraph 10.3, which doesn't use the word if at all. But I think he's saying that the fact that the code can make it quite plain when it means that if it intended to say that it was only a successor in title who was to be treated as a party to the agreement, then it's perfectly capable of saying that. I think that's his point.
I agree that's the point, but he makes it by looking at instances where it says if and only if, and saying that this is obviously a condition for this to be met. And what I am just trying to illustrate is there are many instances in the code where there are situations where if the condition is not met, it does not mean that there are alternatives that one can actually use. And again, it comes down to the fact that when one's reading the code, one has to be astute, not simply to draw linguistic points, but to actually look at what's really going on in the underlying structure of the code.
Yeah.
Can I now turn to issue 2, which I think my learned friend accepted yesterday that it really would create a black hole in the whole of the code, in that it would stymie any future rollout of infrastructure. And in reality, that this was an in terrorem argument to try and reinforce its arguments under its first issue, namely that it should be a part of the code agreement. And that's the point we actually made in paragraph 40 of our skeleton argument. Can I say also that obviously there is a degree of contradiction in the way APW is arguing this case, because on the one hand it's saying that Part 5 is available and therefore one cannot use Part 4, but at the same time it goes down the route of saying, well, actually the solution would be, the consequence is that APW and Gencomp would both have orders under Part 4.
Just hold on a minute, Mr. Reed. I don't think we need to hear you further on issue 2.
Can I just take some instructions? And see if there's a... I'm grateful, my lords, that those are the submissions, unless there's anything else.
Mr. Clark, any reply?
I do, if I may. I'll try to be brief. The first point I'd like just to deal with is there is canvassed the issue concerning the extent to which, where the operator has a license, the benefit of the covenants pass to the assignee of the grantor's interest. We are dealing on this specific case with a subsisting agreement. And you may recall yesterday I asked you to look at the provisions of the old code, paragraph 2, subparagraph 5. If we turn to tab 17, page 365, so in order to be a subsisting agreement, you have to come within paragraph 2. And paragraph 2 tells us, at subparagraph 5, if you have a right... Sorry, my lord.
Sorry, which tab?
It's tab 17.
I've got landlord and tenant covenant. Oh, I see. It's been tucked in the back. Yeah.
Yeah. Page 365, my lord.
Yes.
Yes, thank you. So this is paragraph 2 of the old code. And then we have in subparagraph 5, so a right falling within subparagraph 1, i.e. an agreement to the purposes of executing works, keeping ECA on land, entering land, etc. A code agreement, essentially. A right falling within subparagraph 1 shall not be exercised except in accordance with the terms, subject to which it is conferred, and accordingly, every person for the time being bound by such a right shall have the benefit of those terms. Now, given that we know under the terms of the transitional provisions, to which my learned friend has referred to just a moment ago, at paragraph 23, we know that a subsisting agreement has effect after the new code comes into force as an agreement under Part 2 of the new code. So it could not have been intended that someone who is bound under the old code, pursuant to a paragraph 2 old code agreement, and therefore has the benefit of the terms, ceases to have the benefit of the terms. So under the old code, an assignor who is bound of the grantor's interest,
Assignee.
sorry, thank you, my lord, the assignee of the grantor's interest obtains the benefit of the covenant. It could not have
And
been.
the same would apply to a concurrent lessee.
Well, of course it would, because you have the landlord and tenant provisions dealing with that. It would also apply.
If the operator's agreement is a mere contractual license, I understood Mr. Reed to say that the concurrent lessee would not get the benefit of the license fee.
What I say is that the concurrent lessee is bound under the old code.
Yes, but this is not a 1995 Act point.
It's not a 1995 Act point.
It's an old code point.
It's an old code, in which case the point being is that the person bound, whoever that may be, obtains the benefit. So the concurrent lessee obtained the benefit of the covenant. So this is the point about how is it a contractual license where the operator only has a contractual license? What happens on the transfer of the grantor's interest?
That may be so in the case of transitions, but what the Deputy President said is we're looking at the structure of the code. So how does it work with an agreement, let us suppose, granted for the first time under the new code, and then you come on the scene subsequently?
I accept that that's a transitional provision.
Yeah.
What it does show is that when it emphasises and accordingly, as I submitted yesterday, it must have been in the drafter's mind necessarily implicit in being bound that and accordingly you are subject to the, or you have the benefit of the covenant.
But you don't have those. You don't have those words in the new code.
You don't have those words in the new code, but that's why the words "and accordingly" are all important, because "and accordingly" in my submission indicates that it is implicit that being bound confers.
Sorry, you're talking about "and accordingly" in the new code.
In the new code, no, in the old code.
In the old code.
In the old code,
So we can construe the new code
when
with
it says to
reference
be
to
bound.
the intention of the drafter of the understanding of the drafter of the old code. That's quite a difficult stretch.
I accept that the words "and accordingly" and those that follow are omitted from the new code. I accept that. But one reason for their omission is that it was thought that it was necessarily implicit that the benefit would pass. If the benefit had passed in relation to a subsisting agreement, and in relation to that subsisting agreement, which is continuing under the new code as a Part 2 new code agreement, what you would then be having is a two-regime system, one for subsisting agreements where the benefit has passed, one for new code agreements where the benefit doesn't pass in relation to a contractual license vested in the operator. That doesn't seem right in terms of the way the code should work.
Isn't it a bit, this is the tail wagging the dog, isn't it? Using what happens in the transitional period to inform the code.
Well, my lord, clearly it works in this case.
Yes, well, I see.
Yes, it clearly works in
Yes,
this case.
but as my lord has said more than once, we're trying to work out
I
how the
accept
structure of a new code as a self-contained code works. And for my part, I have great difficulty in seeing we can construe a new code by reference to transitional provisions carrying over inherited arrangements from the old code.
Well, it's not a carrying over, it's the accepting that the words "and accordingly" the benefit is vested in the assignor are omitted from the new code. The reason for that omission, in my respect, is that it was considered necessarily implicit, because it's the words are prefaced by "and accordingly." So being bound.
So you're saying that and accordingly shows that it was the consequence of being bound.
Absolutely.
And that analysis ought to apply.
That analysis ought to apply in the new code. The second point on that is that although we don't have the provision here, as my learned friend was speaking, I see no reason why, given that, of course, the grantor's interest with respect to paragraph 10 is always going to be, in the context of paragraph 10, a legal interest, why isn't a contractual right vested in the operator caught by section 63, the all conveyancing of rights and claims and demands passing on the conveyance under section 63 of the Royal Property Act 1925? I pass my land over to you. It carries with it, it's effectual, to convey not only the estate, but all rights, title, interest, claims and demands. I don't see any reason why that cannot carry with it the benefit of a contract that is vested in the operator.
Sorry, section 63 of the
Section
law.
63, my lord, of
Or
the
the
Law
Law
Property Act
Property
1925.
The all estate clause.
All estate clause. But it's not limited to just the estate.
No.
So, my lord, that is what I wanted to say in relation to the question of the operator's interest.
Do you get them under section 141? Is it a covenant?
Well, under section 41, of course,
Well, it's been replaced by the 1995.
it's been replaced by the 1995 Act, yes.
And the 1995 Act.
It relates only to a covenant. Now, of
And
course, it's not by deed. One is assuming that the contractual license is not by deed. So,
Okay.
yes. So, thank you. That's what I wanted to say on that. In relation to the dual system, there's a lot of debate about the dual system. Nevertheless, works. So you have Part 5 under Gencomp, Part 4 against APW. One of the points that was raised by my Lord Justice Lewison was that my Lord said, well, the impasse, the inability to redevelop that APW may be confronted with is overcome once the Part 4 agreement is imposed, because then APW has the opportunity to incorporate a break. True it is it cannot terminate, but it can incorporate a break. Of course, one mustn't forget, as your Lordship mentioned to my learned friend during questions, Part 4 is optional. So the impasse is only overcome if the operator were to implement Part 4. There's no mandatory requirement for it to implement Part 4 at all. Yeah. The other point to make on that is that it is also a rather odd way of having to overcome the impasse. What I want to do is to redevelop now. I want to terminate now, rely on Part 5 now. I'm unable to do that. So what I have to do is to go through a regime that requires me to have two sets of proceedings. One to incorporate the break, which could be resisted, and the second then to terminate the code agreement that's been imposed on me under Part 4. So I don't have the simple expedient of simply saying I'm a party to the code agreement, I'm going to terminate because I want to develop now. I'm frustrated in my development until I obtain a break. One set of proceedings, then I have to terminate, second set of proceedings, and succeed on that.
But you as a lessee have taken a lease subject to code rights to which you know the occupier is subject. Surely, as part of your due diligence and then proper protection of your rights, would want to have a suite of provisions to ensure that you can do what you want vis-à-vis the landlord.
Well, as a landlord, and other than with the consent of the operator, I cannot agree, I cannot impose upon the operator a break clause to terminate the operator's contract.
No, but forgive me. Surely you would include provisions in the lease which would enable you to require the landlord, the freeholder, to do whatever needed to be done under the code right agreement, the code agreement, to protect your position.
With respect, the superior lessor is never going to be able to protect my position under the code. The reason for that is, as the Deputy President made clear, is because there will always be in existence the concurrent lease. I would have to then agree, in order to be able to redevelop, that something would have to happen to the concurrent lease, because if Gencomp wanted to resist or terminate, the operator's code agreement under paragraph 31, it would have to show, assuming it's a redevelopment ground, that it intends to redevelop.
No, I think what my lord is putting to you is that the concurrent lease would itself contain provision requiring the superior landlord to advance the redevelopment case on your behalf.
There are a number of difficulties with that because 31.4 requires the intention to be that of the site provider.
Yeah.
And we know from the case law under the code, it's in the bundle, it's I think tab 12, we don't need to look at it right now, but EE and H3G against the trustees of the Mayrick estate said that the 54 Act applied, the case law under the 54 Act applied to the meaning of paragraph 21 subparagraph 5 about development, intention to redevelop, and therefore it would necessarily apply to 31.4c, which requires an intention, and that has a very clear meaning in the case law under the 54 Act.
Yeah.
That
It has to be the landlord's intention.
has to be the landlord's intention. But the whole, the Mayrick Estates case said that body of law will apply subject to suitable adaptation. Betty's Cafes, which is a decision in the House of Lords that says you have to determine it at the date of the hearing, applies. And Francis and Cavendish, which says, in the Supreme Court decision, that says that you have the acid test, that you have to do the work. You would have done the work even if the tenant had vacated voluntarily. All that applies.
I seem to remember, though, it's a long time since I've actually done these 54 Act cases, that the landlord could satisfy ground F by granting a building lease which gave him sufficient control over how and what the tenant did.
That is so, my lord, and that is obviously a workaround. That would require APW or someone in its position in the future having to surrender its interest on at some stage and then receive it.
Why couldn't it
have
be
to
built
take
into the
building
lease from the
wouldn't you?
start?
Oh, you could have a building lease from the start, but the effect of the Upper Tribunal's decision, of course, is retrospective in the sense that there are many overriding concurrent leases out there. And so you'd have to undertake a workaround, and that workaround would require a surrender, which would require an agreement of the freehold owner. Why would, in this situation, we know that Gencomp is not interested on the specific facts. Why would it be interested to do that, other than by being compensated handsomely for that particular workaround? The other matter that I wanted to mention in relation to this dual analysis is that one of the features of Compton Beecham in the Supreme Court was that it was saying, well, one of the reasons why you have to have Part 4 is to avoid the operator being ransomed for new code rights. Well, it works the other way in this particular case, because if APW was wanting to enter into a voluntary agreement, which is entitled to pursuant to Compton Beecham, it can be ransomed by the operator, because the operator says, yes, we'll enter into a voluntary agreement, but for an appropriate consideration. Otherwise, no, we're not doing it. But we'll go under Part 4, and under Part 4, of course, they would be subject to the statutory basis for assessment and consideration. But until that Part 4 claim is initiated by the operator, it can ransom concurrent lessee. The other final point on this duality is on the paragraph, on the Part 5 claim as against Gencomp. This is the transposing of the flip from Part 5 as a conferral agreement to one where Gencomp is bound. Now, there is a material difference because Gencomp under a Part 5 claim is met with a clear indication, because there's no qualification. It is a presumptive satisfaction of paragraph 21 contained in Part 4. So Gencomp has no opportunity of saying in relation to the application to be bound by APW's rights, you do not satisfy paragraph 21 because it's subject, this is a so-called renewal under Part 5. So under Part 5, paragraph 21 doesn't apply. We've seen that in the provisions. We saw that in paragraph 34. Paragraph 34 of the code. It's page 439, my lord, paragraph 3411. In considering the orders, and that applies to all of the orders, paragraphs 23, 2, 28, 24, 25 and 84 apply, not 21. So the Gencomp is all but met with a fait accompli. What can it do? It cannot seek to rely on the provisions in paragraph 21. All it can seek to do is to suggest within the context of the renewal that it shouldn't be bound. So there is, we submit, a substantial difference.
Yeah.
My Lord also mentioned in relation to the question of Gencomp and termination and raised the issue about rent. And I think my learned friend said, well, if it's the case that Gencomp wanted to complain, then there could be an argument about that. I think it may be that Gencomp is not entitled to the rent. APW raises it on a Part 4 claim if there's a substantial delay via some form of prejudice. I think that was the way my learned friend was putting it. Gencomp is not entitled to the rent. APW has a Part 4 claim against it. How do you deal with a substantial non-payment of rent? And my learned friend said, well, it's all dealt with under prejudice. Your Lordship then said, well, it's suitably compensated by an adequate monetary payment. And then my learned friend said, well, public benefit. Now, on public benefit, there has been a clear statement by the Upper Tribunal. Unfortunately, it's not in the bundle, but there has been a clear statement.
Well, isn't that point, is that not answered by your submission that paragraph 21, which has the public benefit test, doesn't apply to Part 5?
Doesn't apply to Part 5, as against Gencomp. But my learned friend was trying to introduce these. I thought the question from your Lordship to my learned friend was, what about long-standing non-payment of rent by Vodafone, and there's a Part 4 claim.
I think his eventual answer to that was it's a substantial breach of obligation, under subparagraph A.
Yes. Of course, well, vis-a-vis APW on the Part 4 claim, APW is unable to introduce termination. There's no termination provision on the Part 4. So he's then suggesting, is he, that Gencomp can terminate because of the non-payment to APW, and Gencomp then relies upon 31(4)(a). It just doesn't make sense with respect.
Why doesn't it make sense?
Well, because if you look at 34(1)(a), 31(4)(a), apologies, my lord, 31(4). He's accepted that the rent, on the facts of this case, he's already accepted that the rent isn't due to Gencomp. The rent is due to...
It's still an obligation under the agreement.
It's an obligation under the... It's an obligation under the contract that exists with Gencomp and Vodafone, but in respect of which Gencomp has agreed that the satisfaction of that obligation is to be discharged by payment to APW. And we know that on the facts of this case, on the specific facts, there is an absolute assignment clause, clause 2.2.
But you wouldn't need that because you get it under the 95 Act anyway. As I understood it, Mr. Reed accepted that the rent belongs to APW, but he said there is still a contractual obligation by Vodafone owed to Gencomp to pay the rent, brackets, to APW. And Gencomp can rely on that.
Well, they may be able to rely on it, but living in the real world, it's never going to be terminated, is it? Because if you have a 125-year concurrent lease, the superior landlord is complaining that there's a breach of the terms of the agreement vis-a-vis its concurrent lessee. What's it to the superior lessor who has a reversion in 125 years' time?
Well, that brings in the ought not bit of ground 4A. Which again,
it's unrealistic.
Under
It's
the
unrealistic.
4 Act gives the court a discretion.
Yes. With respect, we say it's simply unrealistic. Thank you. Yeah, and even if there is a potential for termination by Gencomp, of course, APW is not able to resist the imposition upon it of the Part 4 claim by reason of the non-payment, because that is not a ground of termination. So I'd like, if I may, just quickly to go back over this main point that my learned friend mentioned just about, the thrust, the approach to interpretation. And he started out with his submission that was that there should be the approach to construction is to treat the code as a self-contained set of rules to govern and regulate code rights in all situations. And that the issues of interpretation should be considered solely by reference to the code without regard to other principles, such as he calls them in the skeleton, esoteric principles of landlord and tenant. Now, the first point to make is he made exactly the same submission for the Deputy President. The Deputy President rejected that as an approach to statutory interpretation of this code. That's paragraph 65. Well, I only make a very small point, is that it may be that I've misunderstood the CPR, but there's no respondent's notice to seek to justify the Upper Tribunal's decision on the basis that the judge ought to have found that that approach to construction was the right one. I only make that as a small point. It's a small point, there's no respondent's notice. But let's look at this, let's look at the position with respect to, is it to be viewed as a comprehensive set of rules? Now, the first thing is that he repeatedly mentioned that a concurrent lessee is an outlier. With respect, we are not outliers. The Deputy President himself said it was not an uncommon form of property arrangement. We're not outliers, we're not isolated. The second point is that he relied on the decision of the University of London and CTIL. The quotation that he referred to yesterday, my Lord Justice Lewison said, so far as possible, one looked just at the code. The words were so far as possible. In other words, your Lordship envisaged circumstances where one may have to look outside the code. And in our respective submission, there are other circumstances. For instance, from the Compton-Beecham decision, it would seem that the definition of occupier, who is an occupier, is a matter of common law. And your Lordship's definition in the Compton-Beecham case appears, in my respectful submission, to have withstood the decision in Compton-Beecham in the Supreme Court. It's still a good test. And we see that at paragraph...
What I said.
Well, I'm about to show you, my Lord. Paragraph 71 of the Compton-Beecham decision, tab 13, page 308.
Well, I mean, your point surely is that the code is not enacted in a vacuum. It's enacted against the background of contract law and property law, which has been developed in this country for hundreds of years.
Yes, absolutely. Well, I only make this as a small point. We see that reference there to the Court of Appeal.
71.
71, page 308, my Lord. That's a question of fact rather than legal status. This is what your Lordship said in the Court of Appeal. Whether a person is an occupier is a question of fact rather than legal status. It means physical presence on and control of the land. That test is still the right test for determining who is the occupier. That's a common law test. You have to go outside the code, notwithstanding the definition of occupier in 105. Occupier for the time being. To understand what occupier means within paragraph 105, occupier for the time being, you have to look at the common law. It's not self-contained within the code.
Well, that's throughout the code. You've got references to things like interests in land.
That's right. That's why my Lord Justice Lewison said it's not enacted in a vacuum. So there are still other elements that one has to have recourse to, such as the one I mentioned earlier, in the context of paragraph 31(4)(c) and paragraph 21(5), the question of redevelopment. Yeah. We know from the Upper Tribunal's decision that the whole concept of intention within the code is now going to be understood by reference to another body of law within the context of the 50 Law Act. That body of law is now incorporated into the code, says EEH3G against the Trustees of Merrick Estate, tab 12, paragraph 38. The other matter about, in terms of landlord and tenant generally, one still has to grapple with landlord and tenant because one still has to identify, particularly when you've got a complex chain of interest, there may be multiple concurrent leases, as we know in arrangements, in property arrangements. You have to then understand the position as a matter of property law. You determine, according to him, whether it's part 5 and part 4, and who you go against. So you're still having to grapple with these so-called esoteric matters. In relation to the question of the code not dealing with an operator, my Lord Justice Nugee summarised, if I may say so, my submission on that point. I don't wish to repeat that as to the
Para 16 point.
Yeah, the Para 16 point, and as to why that's important in terms of, i.e., the code is not exhaustive.
We have that point.
Thank you so much. And then there was, in terms of the approach to construction, the court asked yesterday, well, how did the Supreme Court reach its conclusion? It starts off at 106 with page 315. Is Lady Rose says, letter F, correct approach is to work out how the regime is intended to work and then consider what meaning should be given to the word occupier to best achieve that goal. And then what Lady Rose then did is to then go on to consider a number of points as to why it was right that the operator's occupation, when it was seeking new code rights, was to be, as it were, tuned out, was to be disregarded. And she starts her analysis at paragraph 119. And she, the first point is she talks about future-proofing. It's a waste of time and money for operators to have to keep putting everything in a code agreement without the opportunity of going under Part 4. That doesn't apply by analogy to our position. But the second argument does, in my respectful submission. What she said is, if the code is supposed by the mechanism Para 9 to prevent the operator from being able to change its rights during the initial fixed term, that has only been partly achieved. Mr. Pymont accepts there are some operators who install EC on site but not thereby become occupied. For example, if they merely fix antenna on a roof. And then she said she agrees with Mr. McGee's submission that this makes the application of Part 4 of the code arbitrary. So there's 2 points being made. One point is that the code has only achieved partially what it was intended to do. And the second is it's arbitrary. Well, both of those points are, in my respectful submission, applicable here. We know that if and insofar as concurrent lessees are to be excluded from the code as parties to a code agreement under Part 5, that is only partially affected because we had the issue with respect to subsisting agreements. We know that the position with relation to an agreement that concerns partial code rights, that is going to be dealt with under the 54 Act, and a concurrent lessee is able to deal with that. And we also know that if the concurrent lease is over an existing operator's lease, which is a lease, which is an old lease under the 1995 Act, that's an assignment of the reversion and therefore is a party because of the assignment of the reversion taking effect in relation to a pre-1st January 1996 lease. So that point, if and insofar as concurrent leases are to be excluded from the code, that is only partially effective. Secondly, it is arbitrary. The exclusion of concurrent lessees is arbitrary. May I just try and present a couple of examples? The first is that you could have a freehold transferred with a call option. So you could have that, let's say, a 999-year term with a call option after 999 years. That's fine because the freehold's been transferred. The transferee is a party to the agreement. But if you grant a lease for 999 years, it's not. So it depends whether or not you just transferred it subject to an option back after 999 years, or you just grant 999 years. So one is caught by the code, the other isn't caught by the code. Take another example. I sell the freehold. I've already granted the operator an agreement. I sell the freehold. I take a transfer back. So I'm now a concurrent lessee.
Take a lease back, you mean? You mean you take a lease back?
Take a lease back. What did I say, my lord?
You said take a transfer back.
I take a lease back. Thank you. I take a lease back. Transfer the freehold, take a lease back of the property. I'm now a concurrent lessee. It could be said, I suppose, that I'm still a party to the original conferral agreement in my capacity as tenant, albeit I conferred it as freehold owner. But as we know from experience, I may wish to take the lease back in the name of another member of the group. And suddenly, by the quirk of not leasing it back to myself, but leasing it back for proper good commercial reasons to a member of the group, I am now no longer to be treated.
Well, I think Mr. Reed would say that's your lookout. You must make sure that your arrangements achieve, your contractual arrangements achieve what you want them to achieve.
Well, the fourth point that Lady Rose did make in relation to her analysis was that in paragraph 126, she mentioned the fact that, yes, it's true, essentially, what she's saying at paragraph 126, page 320. She's saying, yes, it's true, there may be workarounds. She says, last sentence, although such an exercise may be available as a workaround, it seems very unlikely the new code was supposed to generate this kind of activity. Well, we say exactly the same in relation to concurrent leases. Yes, it may be that there are workarounds, but is it really the case that one says that the policy and Parliament's intention was to give
Well,
rights?
essentially your point is that we should interpret the code in a way that it works, that doesn't require the adoption of workarounds.
Doesn't require the adoption. And in my respectful submission, we are not distorting the language of the code. We come within paragraph 5, part 5.
Yes, all right, we've got that.
Thank you. Yes, may I just mention one other point in relation to the suggestion that the code is all-encompassing. Of course, the point was made yesterday that in order to be a party to a confer agreement, you are required to sign the agreement. That is not true in every case. And the reason why that is not true in every case is that it has been made clear by the tribunal in the decision of E.E. Hutchinson and the London Borough of Islington, the Deputy President, tab 10. Don't need to look at it, it's just the reference, paragraph 148, page 219, that where you have an order under part 4, paragraph 20, it is the order which takes effect. There is nothing further to be done by the parties by way of executing the agreement.
That's because the code says that an order takes effect as if an agreement had been executed.
It does, but it's still an exception to the suggestion you have to have writing. It's treated, it's deemed to be a Part 2 agreement, notwithstanding the absence of being signed by the parties.
Now, I thought, actually, that Lady Rose said something different. But anyway, somewhere or other, and she's contrasting the old code and the new one.
I think there's a difference between an order which takes effect directly and an order which takes effect by treating it as an agreement. But I'm not sure it helps us, does it?
It is simply an example of where one doesn't need writing. Yes, it is true, it's treated as a Part 2 agreement, but the parties themselves haven't actually executed it. May not take matters much further, but it is worthy of note in my respect. The other point to think about in terms of the approach to interpretation is that my learned friend has repeatedly said the policy is all about rollout. When the DCMS report indicated that the code was about to hit the streets, it was made clear that it's a balance. It's a balance between the respective interests. The code itself is meant to reflect a balance between the interests of the site providers and the operators. And we see that at tab 33, page 38. Sorry, page 538. I do apologise, page 534. Tab 33, page 534. What the the ministerial forward said, penultimate paragraph, these changes are just some of the highlights of the new code. The overall package of reforms being put forward strikes the right balance of interest between site providers, communication providers, and most importantly, the public interest in ensuring communication services meet the needs of UK citizens. So it is a balance. My lords, I believe that is everything I want to say. I was going to mention development, but I think I've covered that in my submissions about merit. So unless there's anything further.
No, thank you, Mr.
Thank you
Clark.
so much. That was rather speedy, I'm afraid, but I was conscious of the time. And
Yes.
did not
Well,
wish to.
thank you very much.
Not at all.
Thank you both for your interesting arguments. There's obviously a lot to think about, so it won't surprise you to learn that we will reserve our judgment. You will get the draft in the usual way, which is your opportunity to correct our spelling and grammar, but not our reasoning, not to raise new points. The draft will come with a fierce embargo, which means exactly what it says. And in the light of the draft, we would hope that you will be able to agree a form of order disposing of the appeal. But if you can't agree a form of order, please make short written submissions, and we will make the form of order that we think is appropriate. Thank you very much for your arguments.